You know that feeling, right? When you're just scrolling through headlines, maybe prepping for something, or just trying to keep up, and you just wish someone would cut through all the noise to tell you what's really going on.
Yeah, simplify it a bit.
Exactly. That's what we try to do here on the deep dive. We take a whole stack of sources, pull out the key bits, and give you that shortcut to, being properly informed.
That's straight to the point.
Precisely. Today, we're diving into a really high-stakes legal fight from India. Specifically, a very recent and honestly fascinating decision from the Karnataka High Court.
Mm-hmm.
And this deep dive, it isn't just about some dry court judgment. It really puts a spotlight on that fundamental clash between free speech, personal reputation, and, well, the huge power courts have, especially now, in the digital age.
It's a very modern problem in many ways.
It is. So our mission for you today is to really unpack this specific judgment. We want to understand the tricky nuances and see the wider implications, how information flows, how justice is sought, and, yeah, ultimately, your right to know.
Sounds good. Where do we start?
Okay, let's set the scene for this whole legal drama, because it kicks off with some incredibly serious allegations. It all started, apparently, with a complaint from a former sanitation worker.
Right.
He claimed that over almost 20 years, like from 1995 to 2014, he was coerced into secretly burying human remains. And this was supposedly inside the sacred grounds of Sri Kshetra Dharmasthala.
A very highly revered temple institution in India, yeah. That's a huge claim.
Huge. And the seriousness, it just deepened. The complaint didn't stop there. It also suggested, gruesome crimes, things like rape and murder, and it implicated people directly linked to the temple.
Wow. Okay. So what was the immediate official reaction?
Well, things moved pretty quickly on the legal front.
As you'd expect with allegations like that.
Right. So these claims led to crime number 39 of 2025 being registered at the Dharmasthala police station.
Okay.
This was under Section 211A of the Bharatiya Nyaya Sanhita 2023.
And that specific section, just for context, deals with filing false or malicious criminal complaints, interestingly. So that was the initial angle taken.
Yes. And this, combined with, the public outcry it must have caused,
Understandably.
it pushed the Karnataka government to quickly set up a special investigating team, an SIT, to really dig into it.
Right, a dedicated team.
But wait, there's more. As if that wasn't enough, another sort of related complaint popped up.
Oh.
From a former CBI stenographer, a woman named Sujata Pat. Her complaint was about her daughter, Ananya Pat, who mysteriously disappeared from near the temple way back in 2003.
2003. Well.
And the complaint had these sinister undertones, hinting at maybe a deeper, troubling link to everything else.
So multiple layers emerging.
Exactly. So into this really turbulent situation comes Kudla Rampage. It's a digital media outlet run by a Mr. Ajay.
Okay.
And as you'd expect, they started reporting on all these developments as they were unfolding, bringing it all out into the open.
Covering the story, doing their job.
Pretty much. Now, this is where the plot really thickens. In response to all this media coverage,
Which must have been intense.
Sri Harshendra Kumar D. He's the son of late Ratnavarma Hegade. He launches this massive defamation suit. OS number 5185 of 2025, filed in the city civil court in Bengaluru.
Okay, defamation. That's a common response, but you said massive.
Oh, massive is maybe an understatement.
Really?
This lawsuit, get this, was filed against 338 defendants.
338. Wow.
Yeah. And the list wasn't just individuals. It included huge social media platforms. Google, Meta, Facebook and Instagram, Twitter, or X now, Reddit, WhatsApp.
Good grief.
Yeah.
That's casting an incredibly wide net. Almost everyone involved in sharing information online, it sounds like.
Pretty much. And what was he actually asking the court to do with this suit? What were the demands?
Well, the demands were just as staggering as the number of defendants. Two main things, really significant ones. First, a mandatory injunction. That means asking the court to order specific actions. In this case, the immediate deletion or de-indexing of over 8,800 specific URLs.
8,800. Just specific web pages and posts.
Seems like it, yeah. And second, a permanent gag order. Basically, stop anyone from publishing or even commenting further on these allegations. Total media silence, essentially.
Wow. Okay. So they wanted specific stuff removed and a ban on future coverage.
Exactly. But here's where it gets, as you said, really interesting.
Go on.
The trial court. It actually granted a sweeping ex parte ad interim injunction.
Ex parte meaning
Meaning without hearing the other side.
without hearing any of the 338 defendants.
Correct. And it happened on the very same day the suit was filed, July 18th, 2025.
The same day. So file the suit, get the gag order just like that.
Pretty much. A drastic decision made instantly with zero input from the defendants.
Okay, just wrap my head around that. What was the immediate effect?
Well, think about it. An almost instant total media blackout on the topic.
Because the order didn't just hit the 338 named parties, right? You mentioned something else.
Right. It included a John Doe provision. That means it aimed to silence even unknown future parties who might comment.
So anyone, anywhere.
Potentially, yes. And it ordered the deletion of all existing published content related to the FIR or Dharmasthala. It basically tried to erase the public conversation overnight.
That's a genuinely chilling effect, isn't it?
Absolutely. A massive immediate impact.
So faced with this, incredibly broad and sudden order, Kudla Rampage didn't just accept it.
No, they fought back. Represented by their advocate, Shriye Velan, they challenged it.
Where did they go?
They went straight to the Karnataka High Court. They used Article 227 of the Constitution.
Okay, Article 227. Remind us what that does.
Basically, it gives high courts the power to supervise lower courts, to step in and correct errors if they see them. So it was Kudla Rampage's way of saying, hey, High Court, the lower court got this seriously wrong.
Gotcha. A crucial check and balance. So what were their main arguments?
They laid out several key points. First, they argued that the trial court essentially gave the plaintiff the final thing they wanted, deletion. Silence, but at the very start of the case, the interim stage, and crucially, without hearing the defendants.
Okay, jumping the gun, essentially.
That was the argument, yeah.
Yeah.
Second, they pointed to Order XXXIX Rule 3 of the Civil Procedure Code, the CPC.
Right, you mentioned that before.
Yeah, it specifically says courts must give reasons if they grant an injunction without giving notice to the other side. It's a basic fairness rule. They said the trial court failed to do that.
No reasons given for the urgency or lack of notice.
Apparently not recorded, which was their point. Third, a big one. They argued it flat out violated Article 19A of the Indian Constitution, the fundamental right to freedom of speech and the press, muzzling them unconstitutionally.
Makes sense. And the John Doe part.
That was the final main point. They argued that including this John Doe order, trying to restrain even unidentified people, was just way too broad. It risked silencing legitimate public discussion on something really important, a matter of grave public interest.
Okay, so procedural flaws, constitutional rights violations, overbreadth, pretty strong arguments.
Definitely.
So what did the plaintiff, Ashok Kumar D., say in response? Their lawyer was senior advocate Sri Udayahala, right?
Correct. They had counter-arguments, of course. First, a procedural one. They argued Kudla Rampage shouldn't have used Article 227 to come to the High Court directly. They claimed the proper route was an appeal under a different rule, Order XXXIX Rule 1 of the CPC.
Sort of. You're in the wrong court, using the wrong door.
Basically, yes. Then on the substance, they hit back hard. They insisted the content Kudla Rampage published was false and malicious. They even claimed it repeated defamatory stuff despite previous warnings or orders.
Okay, doubling down on the defamation claim.
Exactly, and they brought in another fundamental right, Article 21, the right to life and dignity, arguing that reputation is part of that.
The reputation versus free speech conflict front and center.
Precisely. They argued Article 21 deserves strong protection from what they called media trials. And to show the real-world stakes, they pointed out that these allegations could seriously damage public trust in their institutions.
Which you mentioned, employ and educate a lot of people.
Yeah, over 75,000 employees and 45,000 students, so they argued the potential harm was immense.
Okay, so a real clash of rights and procedures argued before the High Court.
A classic legal battle, really.
Now, with this incredibly broad order hanging in the balance, all eyes were on the Karnataka High Court, and Justice M. Nagaprasanna delivered the judgment on August 1st, 2025. What did the High Court decide?
Well, Justice Nagaprasanna delivered a very detailed judgment, and ultimately it overturned the trial court's order completely.
Okay, why? What was the reason?
The High Court made some really critical points, especially about these kinds of ex parte injunctions, the ones given without hearing the other side, and particularly mandatory ones, which order someone to actively do something, like delete content.
Right, not just stop doing something, but take positive action.
Exactly. And the court, leaning on several important Supreme Court precedence cases you might have heard of, like Dorab Kawaji Warden, Mode Matab Khan, even the more recent Bloomberg v. Z case, and Shiv Kumar Chadha.
Okay, established law.
Established law, yes. The High Court stressed that these mandatory injunctions, especially ex parte, should only be granted in the rarest of rare cases. And even then, only with very strong, clear, cogent reasons. It's meant to be an exceptional remedy, not the norm.
So a very high bar to meet.
Extremely high. And the High Court found a major procedural problem here.
The Order XXXIX Rule 3 thing again.
Exactly. The High Court found that the trial court failed to record any reasons explaining why it was necessary to grant this drastic order without first serving notice on the defendants.
So it didn't explain the urgency or why fairness could be bypassed temporarily?
Precisely. And that failure, the High Court said, was a direct violation of that rule, Order XXXIX Rule 3 CPC. It's a fundamental aspect of procedural fairness designed to stop courts from acting arbitrarily. This lack of recorded reasons was a huge issue.
Okay, so the procedure was flawed. What about the substance, especially that John Doe part covering everyone?
The High Court took a very strong view on that, too. Granting such an incredibly broad order, affecting potentially anyone without hearing the parties involved, that goes against basic procedural fairness.
Seems obvious when you put it like that.
Right. The High Court basically said this order amounted to pretrial censorship and prior restraint.
Those sound serious. What do they mean exactly?
They are serious. Prior restraint means stopping speech before it even happens. It's generally viewed very negatively in free speech law, including in India, because it's such a powerful tool for silencing expression. Pre-trial censorship is similar, deciding something is defamatory or harmful before a full trial has even determined the facts.
So the court felt the lower court jumped the gun massively.
That's the essence of it. The High Court was actually quite critical of the trial court's 5-page order.
Even though it was 5 pages long.
Yes. Justice Nagaprasanna noted it conspicuously lacks the foundational reason required for grant of such extraordinary relief.
Ouch.
And then came that really memorable line from the judgment. I think it's worth quoting directly. Mere volume cannot substitute judicial evaluation, nor can length masquerade legal necessity. It is application of mind that is required in a reasoned order and not application of ink.
Wow. Application of mind, not application of ink.
That's powerful. I'm basically saying you wrote a lot, but you didn't think enough or explain why.
That's exactly it. A powerful critique of just going through the motions without proper judicial reasoning.
And on the John Doe, or Ashok Kumar, orders, as they're sometimes called in India?
The High Court acknowledged these orders exist in Indian law. They can be used. But it issued a strong caution. They must be wielded with great care and judicious foresight.
Why the caution? Because by definition, they apply to unidentified people. They carry the risk of overbreadth. They can accidentally silence perfectly legitimate voices.
Catching dolphins in a tuna net sort of thing.
But a good analogy, yes. The High Court concluded that this particular order had cast its net so wide that it threatens to ensnare any voice against the plaintiff, the family, or the place. And importantly, it failed to specify what kind of statements were actually considered defamatory to justify such a blanket ban.
So too broad, too vague, and procedurally flawed.
That sums it up well, which led to the final decision.
Which was?
The High Court decisively set aside the entire ex parte ad interim injunction order from July 18th. Gone.
And the reasons were clear.
Very clear. It summarized them. 1, procedurally flawed violating Order XXXIX Rule 3. 2, substantively excessive, basically a prejudgment verdict. 3, constitutionally impermissible violating Article 19(1), freedom of speech. And 4, just not justified by the plaintiff's own affidavit and pleadings. The case presented didn't warrant such an extreme measure.
Okay, so the gag order is lifted. What happens now in the case? And what does this mean for, us, the listeners?
Good questions. The immediate effect is the High Court sent the case back down to the trial court.
To start over on the injunction request.
Essentially, yes. The instruction was, hear all the parties properly this time, consider their arguments, and then pass a reasoned order on the plaintiff's applications for injunctions. Due process has to be followed.
Got it. So the fight over whether there should be any restrictions continues, but fairly this time.
Exactly. And crucially, the High Court was very, very careful to state that it expressed no opinion whatsoever on the actual merits of the case.
Meaning?
Meaning it didn't say whether the defamation suit itself is valid, or whether the criminal investigation should proceed, or whether the original allegations or the counterclaims are true or false. None of that.
Okay, so this ruling was purely about the way the temporary gag order was issued, not about who's right or wrong in the underlying disputes.
Precisely. It was all about the procedure, the scope of the interim order, and protecting fundamental rights during the legal process itself.
So what this case really highlights for you, listening, is that constant tightrope walk courts face, isn't it?
Absolutely. How do you fiercely protect someone's reputation, their good name, which is important,
Right. Article 21.
while at the same time safeguarding what's really a cornerstone of democracy, the free flow of information, the public's right to know, freedom of expression under Article 19.
It shows how vital that judicial oversight is, stopping potential overreach, especially when serious allegations surface about powerful entities or in matters of huge public interest.
Definitely. It underscores the importance of courts in ensuring fairness before making decisions that can silence voices.
This case, yeah, it truly does highlight that delicate, often difficult balance courts have to strike, protecting reputation versus upholding free speech and the press. It's a tension we see playing out again and again in our, well, very information-saturated world.
It really is. And it leads you to wonder, doesn't it? In this age where information, and sometimes misinformation, spreads like wildfire online, where does the responsibility really lie?
Responsibility for what?
For verifying serious allegations before they become public knowledge? Is it the media, the platforms, individuals? And how can the legal system step in effectively to deal with genuine defamation when it happens, without accidentally shutting down important public debate or investigative journalism? It's such a complex challenge for courts everywhere.
Yeah, finding that line seems incredibly difficult. So maybe a final thought for you to ponder based on this deep dive. Thinking about this case, what do you see as the single biggest challenge for courts today when they have to weigh free speech against reputation? Especially maybe when these serious allegations involve powerful institutions or individuals. Where is that line and how do courts find it fairly?
Something definitely worth thinking about.